Our government is in shambles, says Blake Lewis. So we've been covering how the Copyright Office has been somewhat of a dumpster fire of just chaos because the director of the Copyright Office, as well as the librarian, different department, but the director of the Copyright Office, Shira Perlmutter, got fired. And with that quickly came a lawsuit against Trump and a few others saying, "You can't fire me." And the basis that was provided for the firing initially, and this was all very dramatic when we heard about it, people are showing up at the White House and serving letters around to the staff. I mean, there's hundreds of people who work at the Copyright Office and making this announcement. And just to say that, Shira Perlmutter has been removed, at the direction of the president, the White House, and the basis had to do with this statute where Shira came back and she's like, this doesn't apply. She goes, you got it all wrong, and that's the basis of this lawsuit. So now we do have a big update because after the lawsuit got filed, we had been covering that, there had been different things that had happened because she had said, look, I need this emergency injunction. And on the initial, hey, I need you to put me back into place because someone else came in, took over for her. And she goes, I haven't been fired. The only person who's allowed to fire me pursuant to our laws is the librarian themselves. And well, you, President Trump, are not that person. Okay, so that was kind of the basis. And she lost on the temporary restraining order, right? So the temporary injunction to put her back. So she appealed. So in the appeal, she pushes it up, right? And she goes, hey, appeals court, take a look at this. And based again on the law, I cannot be removed. And we have an update. Sharing my screen. This is over on Music Business Worldwide. Top U.S. copyright official Shira Perlmutter reinstated as appeals court blocks firing by Trump. So a U.S. federal appeals court has blocked the Trump's administration's attempt to remove Shira from her position as the register of copyrights. So, essentially she was the director, right? She was, in fact, the boss lady in charge of everyone over at the Copyright Office. And guys, look, one of the big things here that was noteworthy was that she had been removed and she had received this email terminating her position within a day, right? 24 hours after after the Copyright Office had released Section 3 of its report on copyright and AI. And this particular section actually went in to analyze the basis of fair use, which is a judge-made doctrine. And pursuant to fair use, it's 17 U.S.C. Section 107. And there's 4 factors. And basically, there are times where a company, a person is allowed to take creative things and to use them in their videos, in their songs, in all kinds of ways, right? Without permission. And it's a way that you can essentially get away with copyright infringement. It's a pass. And so the reason why this has been interesting to watch is that we do know that the current administration is definitely pro AI, wanting to be kind of like a leader in all things AI, as this has become a competition, an international competition of who's going to get there first, right? And so understanding that trying to put parameters and limitations on AI companies is not what everyone's wanting to do. But what we've seen happen is that creators are getting trampled in the process as these AI companies are very quickly becoming multi-billion-dollar companies in some cases as little as 12 months. Okay. But they're also getting sued. They're getting sued left, right, and center from all kinds of creators who are claiming you AI companies took our creative stuff, our books, our movies, our pictures, our paintings. And it turns out, in fact, that's what these companies did. And you otherwise needed to get licenses. You needed to purchase copies. This is how it works. You don't get just to come as a new business and be like, hey, I'm new. I'm going to take everything. So that's kind of how this goes. But anyway, so lots of lawsuits. And we know that with the current administration, Shira and the Copyright Office, they then put out this report being like, hey, pursuant to fair use, what the AI companies are doing, not so fair. And in fact, they probably do need to pay. And in fact, what they did does not qualify as fair use. So actually, it was kind of anti, AI, so to speak. So anyway, she gets fired. And we have no reason to believe it was because of that report. Maybe it's just a coincidence. So she gets fired. Let's go back to the article. So the injunction, right? Pending appeal filed, which was yesterday, temporarily reinstates. So now she's back in position. So she filed the thing. She got reinstated, and that prevents President Trump's administration from installing executive branch officials to run the Library of Congress and the Copyright Office. Right? So that had been, a big part of this, of just being like, you are using executive branch stuff and you're pointing to a statute that has nothing to do, right, with this completely other branch. And so that was kind of the basis of the argument. So the saga around Perlmutter's ousting started in May 2025 after the Trump administration fired Carla Hayden, which was the library, and she was the librarian of Congress, and replaced Hayden with Todd Blanche, the Deputy Attorney General, with the Department of Justice. So Blanche then immediately fired Perlmutter from the position of the U.S. Copyright Office, which in part is of the Library of Congress, and replaced her with Paul Perkins as Associate Deputy Attorney General of the DOJ. Perlmutter filed a lawsuit, that same month, claiming her dismissal was unlawful and ineffective after President Trump fired her and the Librarian of Congress via email. So the appeals court, 2-1 decision, comes a few weeks after a judge in the lower court denied her motion. So initially said no can do, right? U.S. District Judge Timothy Kelly ruled on the 30th of July that Perlmutter failed to demonstrate irreparable harm. So guys, just so you know, as a litigation attorney, the way it works is that if you file emergency stuff with the court, so such as an injunction, and you go, Judge, I am filing this emergency thing because I need you to stop someone from doing something in the intellectual property realm, which we are in quite a bit. For example, it might be that, we have a company that is selling on Amazon and infringing our client's trademark. And so we go, we have a big issue we got to deal with here. We're suing for trademark infringement, but in the short term, we're filing this request for the injunction to get you to file, issue it an order so we can actually go to Amazon and be like, you need to literally make this person stop. Because we don't want to wait a year until we win our case, or 2 years when we win our case. So that's what they mean by the judge came back and goes, well, in order to get your injunction, you need to prove irreparable harm. So how are you irreparably harmed if you're not in this position, right, as of right now? So she lost on it originally. So she promptly files the notice of appeal to the U.S. Court of Appeals and signaling her intention to continue the legal battle. The appeals court ordered filed yesterday ruled that her removal in May was likely unlawful and temporarily restores her as the registrar. So she is back in the position of director of the Copyright Office while the case continues. It also stipulates that any actions taken by improperly appointed officials at the Library of Congress have no legal effect while the case continues. So, as you guys have been filing for your copyright registrations, the Copyright Office has still had a ton to do. The volume of which there are filings to get registrations and stuff like that. I mean, all this was going on while the head of the department wasn't there. And then apparently, right, allegedly, someone who had no authority to be there was in place. That's what the court is saying. So saying no legal effect to that person that was in the place at the time. So the order states that Pelly's, Todd Blanche, Paul Perkins, Sergio, Trent Morse, Executive Office of the President, and their subordinates and agents are hereby enjoined from interfering with appellate's services as Register of Copyrights and Director of U.S. Copyright Office pending further order of the court. It adds, quote, to the extent appellant has satisfied the stringent requirements for an injunction pending appeal. In a statement issued on Wednesday, okay, so more things. Now, I kind of want to go to the comments on our side, we are doing this live. There's been a lot happening right now, okay? And I'm sure, obviously, the director is happy to be back in position, but the fight is not done by any means. Wow, she takes her career seriously, it seems. Okay. You know what? The comments aren't quite showing. Yeah, thank you. I don't know why they're not showing. Anyone with actual work experience, our government gets fired. Richard says, was the judge appointed by Trump? James, reputation and income. Let's see. Trump wants to replace everyone with his own people. Well, okay, so what do you guys think? Going back to the original question of, does this seem a little too coincidental? Because one of our big questions had been this. With the report that had been published, it's very important, it was a pre-publication version. It was, and there was a note on it that specifically said, this is the not final version, but not too much should change. And so the first thing I was thinking, because we went through this copyright report in detail, and they did such a great job of just analyzing, how does AI work? What does it train on? What is the process? And so it, in over 100 pages, described not only its interpretation of fair use, but how this whole thing kind of works. But anyway, in the very beginning, it's like, this is not the final version. And so one of our big questions had been, well, with someone new in position now as the Register of Copyrights, are they going to now revise this report? Because, for us, we happen to have class action lawsuits against AI companies for similarly situated alleged misconduct. And as we are pointing to very influential, persuasive, bodies like the Copyright Office, which is the number one administrative, body that can make an opinion on all things copyright, they came out and they sided with what we have been saying and what we were saying as part of these class action lawsuits. So let's see, taken to the Instagram, just awful. The big tech companies are already trillions of dollars. They want to squash creators too. It is something that's happening. I think that even if you are pro AI and you want the expansion and you want to not have these limiters, at the end of the day, it comes with a massive cost. We covered this with how the UK was considering and having real discussions, right, in Parliament on whether they should just kind of unleash the requirements for AI companies. So meaning that they would give a voluntary license for AI companies to go train on whatever they want. And if you want to opt out, you have to go figure out where to go do that as a creator. And we were kind of horrified at what that was, because to me, that just tells me that people don't know how the internet works, because that would be almost near impossible for someone to know where to go, for there to be individual websites that you have to go and opt out of. Now, that didn't become a thing, but as you can imagine, there were a lot of outcries from creatives. There were open letters. Let's see. Vampire Baptism says treason. Michael says the same thing that's happened everywhere else. Well, and that's the thing. I think that in this, we are in competition right now with every other country. We need to be the first. We need to be the best. We need to be the biggest. That is the biggest argument here. But what we keep saying, including with our class action lawsuits, is that when you have companies that just blatantly admit to taking tens of millions of songs and other types of creative works that otherwise, what I'm telling you, as someone who's done this a long time, when you want to use someone's song, you have to go pay for it. When you want to use someone's book, you have to go pay for it. And there are times where fair use applies to these things, but it doesn't apply when you are acting in bad faith. It doesn't apply when you are pirating, when you are stealing, and when you are making something. This is what the Copyright Office said. When you are making something that competes in the exact same marketplace and is the exact same product. So if you take music to then create new music, which is what some of these companies have been doing, it is certainly not fair, and it is certainly not fair use. All right, guys, with that being said, leave a comment down below. We'll leave it there, but we will be back. Don't forget to subscribe. I'm Top Music Attorney, and I'll see you on the next one.